I believe that to understand how the law applies to mentally ill persons, one must know something about the way the law imposes responsibilities on our citizens. First, bear in mind that a mentally ill person had no choice in developing a mental illness, no more than he had in choosing his eye color. Some are born with a gene that causes a condition. Often such illnesses result from some kind of emotional or even physical trauma, such as a blow to the head. Generally, the law is premised on the concept that all persons are responsible for their actions or inactions. But in holding everyone accountable, the law presupposes or assumes that the person acted on his own volition, that he made a bad choice willingly. And as you know, the law makes important exceptions involving crimes. When a criminal defendant's mental condition or competency is placed at issue in a case, this issue comes directly to bear on whether a defendant should not pay the consequences for actions that would otherwise be punishable as violations of law. If under the test for competency or legal insanity, the defendant is found incompetent, he cannot be held responsible for his actions. If he's found competent, then and only then will he be held accountable. When determining whether a person is to be held responsible for allegedly breaking a particular law, we must consider some rhetorical questions. What is reality? Or we might ask, what is real? What does it mean to be aware of something that is real? Is something real in this world because we're able to see it, touch it, and smell it? Or is what we know as reality in life only some kind of illusion or trick played on us by God or some higher power? Asking these provoking questions brings to mind a philosophical one posed by an ancient Greek dramatist, Euripides, who said, "Who knoweth if to die be but to live, and that called life by mortals be but death?" I'll state yet another query. From whose point of view are we seeing reality? When performing your duties as police officers, you may come across a situation in which your own reality may not be the reality of the person you're confronting. Asking these questions brings us essentially to what mental illness does. It affects the mind's processing of what the mentally ill person senses as reality. What he sees, what he hears, equally important, why things he sees happening are happening. It also affects his perception of what to him was the past, as well as any conclusions he may have drawn from past events as he perceived them in his own world. All of these taken together, even if delusional, are what make up the reality of the mentally ill. There is a philosophical question by an unknown author that symbolizes why a mentally ill person who commits an act might not be found guilty of a crime when the same identical act committed by a defendant who is not mentally ill would be considered a crime. Is man a shipwrecked sailor on a rudderless vessel at the whim or mercy of whatever wind may blow, or is he the captain of his own soul? Which is the mentally ill person, the shipwrecked sailor, or is he the captain of his own soul? And in considering what is real, don't lose sight of the possibility that you, yourselves, in investigating a crime, scene, or disturbance, may be mistaken about what you think you see and hear. The mind can play tricks on us. Stresses alone created by a confrontation can affect our observations. To illustrate, I'll mention a few unfortunate incidences that have occurred. One of them happened in the Bronx, New York, and made national news mostly because the police officers involved were accused of racial profiling in what took place. You may recall the case. It involved the shooting of Amadou Diallo by 4 cops in front of his own apartment building. He was gunned down by a hail of bullets when the 4 officers mistook his wallet for a gun. There was another sad case in Arizona where a highway patrolman stopped a driver on the highway. As the driver approached the officer's vehicle, he placed his right hand behind him to take something out of his pocket. The officer believed he was going for a gun and shot him dead. Afterward, the dead motorist lying on the side of the highway still held in his hand a worn-out card identifying him as a deaf mute. I'd like to touch briefly on the public's perception of mental illness. It is still considered a stigma by many, rather than a fact of life. In addition, the public generally takes a dim view when a criminal defendant argues mental incompetence or illness as a factor in whether he should be held responsible for his actions. I've come to believe that the public has to be reminded that if one of their own, a family member, a loved one, a friend, were to suffer from mental illness, then they would better appreciate the world of the mentally ill. They would not be so likely to criticize and condemn a system that requires the safeguards for the victims of mental illness. Then they might understand that there are good and valid reasons to apply these safeguards. They aren't mere technicalities. There will undoubtedly be times when you're called to testify in a criminal case. It may be one in which you will have concluded in your own mind, based on what you know of the facts, that the defendant committed the offense and that the jury should find him guilty. That's understandable. We're all entitled to our opinions. But if the police officer isn't careful, forming such opinions can hurt his objectivity, which can create a problem of credibility for him before the jury. This problem can be especially troublesome in a case involving a mentally ill person, where the competency or sanity of a criminal defendant is at issue. The officer, believing that he knows the facts of the case well, may have concluded that the insanity plea has no merit. If he's formed that opinion, the risk is high that it will affect the substance of his testimony. He would do better if he stuck to the facts and left the opinions to the medical experts. So my advice to you, don't go there. Don't ever try to second guess the judicial process, whether the case involves a mentally ill person or not. It's not worth it. Let the system do its job. Let the attorneys, the judge, the medical experts, and the jury do theirs, based on what genuinely is believed to be the truth and the medical facts in the eyes of the experts. And when the case is over, regardless of whether, in your opinion, the outcome is right or wrong, you must both respect and accept the final decision. Our system of justice isn't perfect, but in my view, it's the best judicial system in the world, no matter its flaws. Based on my experience, I'd say that the majority of criminal defendants who are tried for a crime are in fact guilty. But it's equally true that there are some defendants who are tried and found guilty who are in fact innocent. Wouldn't it be nice if the guilty were always found guilty and the innocent were always found innocent? But that just isn't the way things work. Sadly, the guilty will sometimes go free. It is the price we pay for safeguarding everyone's rights. But even more unfortunately, there will always be innocent persons who will be found guilty in our justice system. The most egregious of these cases, of course, are the ones you've undoubtedly read about in the newspapers. The prisoner who's been incarcerated for some 10 or 20 or possibly 30 years is finally freed because recent DNA testing has shown conclusively that he didn't commit the crime. The same has occurred in cases in which a witness on whose testimony the conviction was principally based now recants and tells a different story. Or cases where someone else, years later, is arrested and confesses to the previous crime for which the person serving time was convicted. Simply because we hear of repeat offenders who are caught and convicted time and time again, there arises a perception that persons wouldn't be charged with a crime unless they're guilty of something. So when the public reads or hears of someone being found not guilty, more often than not, it will question the verdict, especially if the evidence was evenly disputed. Nowhere among the cases where the public questions a not guilty verdict is this truer than in those in which the temporary insanity defense is raised or defense counsel argues lack of specific intent due to some mental defect or mental illness. There's another good reason why the public understandably questions such verdicts. Too often, mental illness, competency, or some other mental condition is used as a defense by defendants and their lawyers when such defenses lack merit. In other words, the defendant's attorney really stretches credibility and argues mental illness in a long list of justifications or excuses for a defendant's otherwise criminal conduct. The ordinary citizen looks down with disfavor on such tactics with little or no merit. When this happens, I propose those defendants who genuinely suffer from a mental condition and the facts of the case suggest that defendant may not have been responsible become victims of the false public perception. There are those who might conclude that a defendant is falsely arguing a technicality to get off, even though the defense clearly has considerable merit.